Hey everybody, it is a beautiful Sunday afternoon and we are sitting in the shanty, and this is not what I planned on doing on Sunday afternoon when I took Friday off. But here I am. Why am I here? I'm here because, well, the shanty's really nice, but I'm here working because a lot of you have been asking what's going on with the DOL regulation, what's going on with the DOL regulation, what's going on with the DOL regulation. By the time you get this thing, it's going to be July 1st. The DOL regulation goes into effect on July 1st. Am I going to have to comply with this thing? And I told you we were keeping an eye on what's going on, and lo and behold, something happened. Unfortunately, what happened is very narrow. And while it gives us a hint about what might happen with respect to you, it doesn't decide the question. So let me tell you what happened. Let me tell you what the court did. And then let me tell you what that means. What happened was on Friday, in one of the three cases that are pending regarding this rule, and there's a fourth at the Fifth Circuit involving the 2019 rule, a court in the Eastern District of Texas, a federal court in the Eastern District of Texas, granted a preliminary injunction to block the implementation of the DOL's new rule. Yay, everybody says clap, clap, clap. Easy. They granted a very, very narrow injunction to block the DOL's rules with respect to the state of Texas as an employer only. The court said it is therefore ordered that Texas's motion for a preliminary injunction is granted. Defendants are hereby restrained and enjoined from implementing and enforcing against the state of Texas as an employer the following provisions of the rule. And then they list all the pertinent provisions of the rule. Well, that's great if you're the state of Texas. Not so great if you're a nonprofit sitting in Michigan. But the court said a bunch of stuff in its ruling. Its ruling is 36 pages long that you should take heart from. And that hopefully, maybe even before this thing gets published, or maybe shortly after, maybe I'll have to talk to you twice today, should cause the court to take the next step and enjoin it nationwide, like it did in 2016, this very same court. So what is it it's a 36-page opinion, and part of the reason why it's as long as it is because it goes through all the steps for a preliminary injunction. It talks about Texas' likelihood of success on the merit, and the statutory interpretation, and the balance of the harms, and all the stuff that you do for a preliminary injunction. But none of that really matters to any of you, and we're not going to go through all that. I'm just going to tell you a couple of things that the court said that you might want to take heart from. The first thing they said, and they hoisted the DOL on its own petard. When you have a Department of Labor that changes with administrations and therefore changes its views about certain things, the things that it writes can come back to haunt it, and that's what happened here. Because you recall the 2016 rule was enjoined, never went into effect. Then the administrations changed and President Trump took office. We had the 2019 rule. The 2016 rule was from President Obama's DOL. The 2019 rule, which was much more narrow, much more measured in terms of its effect on employers. Now we have the 2024 rule, which essentially goes back to the 2016 rule, and the court pointed that out. The court said, quote, "The department's 2024 rule reflects a return to the unlawful approach it adopted with the 2016 rule, period," end quote. Tip your hand much? All right. So what did the court do here? Well, the court went and cited a Supreme Court case that came out Friday on the question of Chevron deference. We've talked about Chevron deference in this podcast before with respect to these very rules and the FTC rules. Chevron deference, you will recall, is a doctrine whereby courts are supposed to defer to the interpretations of administrative agencies who are tasked with interpreting and enforcing laws. Chevron deference is a doctrine that's 40 years old. It's been around for 40 years. The current Supreme Court on Friday overturned Chevron deference and said, no. Courts have to use their own judgment. They don't defer to the agency. And if you want to read more about that, one of our partners did a really nice e-alert, and you can find it right here, right here. In doing that, the Supreme Court of the United States cited all the way back to Marbury versus Madison, which is the very first Supreme Court decision and invented the doctrine of judicial review. They also cited the Federalist Papers. The Federalist Papers. Okay? The Federalist Papers were written, I can't even remember when they were written, but they were written before there was a Constitution, in argument for the Constitution. And here's what the court said in Looper. Likewise, under the Administrative Procedure Act, well, the court first said, look, you've got to use your own judgment. That's what the Constitution requires. And then they cite to the Administrative Procedure Act, and they say, likewise, under the Administrative Procedure Act, a reviewing court is required to, quote, hold unlawful and set aside agency actions, findings, and conclusions found to be not in accordance with the law, period, end quote. Again, tip your hat much? So then, like I said, the court went through all these analyses that's necessary for a preliminary injunction to come to its conclusion. And here's where you find some hope that the court will do the same thing for the rest of you. The court, first of all, said the salary level's primary and modest purpose is to identify potentially exempt employees by screening out obviously non-exempt employees, period, end quote. That is a quote from the Department of Labor in 2019 when it was arguing for the 2019 rule, okay? In other words, the salary level test and the salary basis test are proxies, as the court put it, for the duties test, which is the only thing the statute allows you to consider, the duties test. Without a lot of analysis, the court said Texas is likely to succeed on the merits, which means the court thinks Texas is going to ultimately win. That's a requirement for a preliminary injunction. And then they go into statutory interpretation, and they say the next thing here that I think you're going to find interesting. Quote, an examination of the ordinary meaning of the EAP, that's what the court calls the Section 13A exemptions, executive, administrative, professional. An examination of the ordinary meaning of the EAP's exemptions, undefined terms, shows that the exemption turns on an employee's functions and duties, requiring only that they fit into one of the three listed, i.e. executive, administrative, or professional capacity. The exemption does not turn on compensation, period, end quote. Then the court said, look, the application of the salary level test, the salary threshold for the EAP exemptions, only fits within the department's authority, the DOL's authority, under the FLSA. And the quote said this, quote, if at all, only fits under their authority, if at all, to the extent that such threshold serves as a plausible proxy for the categories of employees otherwise exempt by the duties tests. And what they said here is, like in 2016, the salary level test is subsuming the duties test. It's making the duties test irrelevant, and you can't do that under the statute. That's what the court's saying. And then they do something that I think is really cool. They quote Yogi Berra when they say it's deja vu all over again. Here they're referring back to the 2016 rule and how the 24 rule and the 16 rule are similar. Quote, that is precisely the concern with the 2024 rule. The court concludes that the 2024 rule likely is not based on a permissible construction of Section 213A1. As was true of the 2016 rule, the salary level threshold imposed under the 2024 rule effectively eliminate consideration of whether an employee performs bona fide executive, administrative, or professional capacity duties in favor of what amounts to a salary-only test, period. Now, does this ruling help you? Well, the order doesn't. The court's decision doesn't. But their analysis sure does. And we would hope that the court would take that opinion, which they clearly wrote based on the big picture, not just on the state of Texas. And we would hope that as a result of that, we will get another ruling today. Maybe I'll have to come see you twice today if this thing goes out before the court actually does rule. We would hope we get another ruling today that would apply this injunction on a nationwide level and keep you from having to do that. If it doesn't, or if you want to talk about, okay, what do I do today? Give one of us a call and we'll chat through it with you. Thanks. Maybe I'll see you this afternoon.